Dear learner, we are going to have a lecture on legal rights of employees in France in this MOOCs platform. I am Professor Nafis Ahmad Ansari from Department of Political Science of Ali Muslim University. The legal rights of employees in France. With a foundation of laid in the Napoleon Code, French legal rights affirms that every employee is not just a contributor to the workforce but a holder of inherent rights protected and respected. Liberty, equality, and fraternity are not only national principles but the pillars of every worker's legal rights in France, inspired this by motto of the principles of French revolutions. The legal rights of employees in France are grounded in a robust framework that emphasizes social justice, worker protections, and the establishment of fair and equitable labor relations. France has a long history of evolving labor laws to ensure the well being of employees, and the legal rights guaranteed to the workers covers various aspects of their employment. These introductions will provide an overview of the key elements of the legal rights of employees in France. France stands a global champion for employee rights, meticulously contributing a legal framework that safeguards workers and fosters a culture of well being. This commitment isn't mere rhetoric, it is woven into a fabric of French labor law, evident in several key areas. Employee contract, a foundation of rights. Employment contracts in France are the cornerstone upon the edifice of the employee's rights is built. This meticulously crafted agreement, unlike their bare bones counterparts in some countries, are brimming with the safeguards and essential details. Mandatory details. French contracts come pre-filled with crucial information, unlike a blank canvas. They must clearly outline the type of contracts, permanent or fixed terms, job, title, starts with date, working hours, compensation, holidays, and trial periods if applicable. Think of it as a detailed blueprint ensuring both parties are on the same page for the outset. Two main types French contract come into two primary flavors. Permanent, CDI, it is commonly known. Imagine a sturdy oak rooted with stability. The CDI, or the contract on duty indeterminate, offer long-term security with a termination requiring specific justifications and legal procedures. This provides employees with a peace of mind and a foundation of career growth. Fixed term, CDD, picture a temporary bridge facilitating specific projects or seasonal needs. CDDS, or contract a duty determinee, have a predefined end dates and are used for specific tasks or periods. While lacking the permanence of a CDI, they offer flexibility and can serve a stepping stone for permanent positions. Beyond the basics, employment contracts in France delve deeper than just the who, what, and where. They often includes non-compensation clauses. These clauses carefully regulates avoid being overly restrictive, may limit an employee's ability to work for competitors after leaving the company. Confidentiality obligations. Employees may be bound to keep certain companies' information confidential. Then this intellectual property rights. Agreements may be clarify ownership of any inventions or creations of employee makes duration their work, which makes a certain period of time which makes during their work. These additional clause may nuisance and specific to the contract, ensuring clarity and protecting both the employer's interest and the employee's right. protecting every voice regardless of a contract type. All employees in France are entitled to fundamental rights enshrined in the labor code and collective bargaining agreements CBAS, and these rights includes: number 1, minimum wages and overtime pay; number 2, paid vacations and sick leaves; number 3, protections against discrimination; number 4, safe working condition; and the last, freedom of association and union representation. Work life harmony: 35 hours work week. Imagine a timekeeper ensuring regular work weeks don't bleed into the personal hours. The 35 hours work week set a clear boundary, promoting a healthy balance between the professional commitments and the personal life. Generous paid leave: 5 weeks of the annual vacations and 11 public days, holidays, paint a picture of ample rest and renovations. This generosity allows employees to disconnect, recharge, and return work with refreshed and burning with the new ideas. Right to disconnect. In France, the right to disconnect isn't just a suggestions. It's a legal shield protecting employees from constant pings of emails and calls for after hours. This empowers them to truly switch off, prioritize their well-being, and avoid burnout. Unwavering protections. Intelligent dismissal rules. French law doesn't tolerate arbitrary job loss. Intelligent procedures and legal safeguards make wrongful terminations difficult, providing employees with security and peace of mind. Robust social security. A comprehensive social security system acts as a safety net, offering health care, unemployment benefit, and pensions. This financial security shields employees from life uncertainties and allow them to face challenges with confidence. Non-discriminations. French workplaces strives for fairness and inclusivity. Discrimination based on protected characteristics like gender, race, religion, or disability is illegal, ensuring everyone has equal opportunity to thrive. Collective power and empowerment. A strong union presence. Nearly 95% of the French workforce is covered by the collective bargaining agreement CBAS negotiation by unions. These CBAS act as a collective voice, amplifying employees' concerns and ensuring they are heard by employers and policymakers. Industry specific agreements CBAS aren't one size fit all. They can be tailored to the specific needs of each industry or company, ensuring relevant rights and benefits that address unique challenges faced by different sectors. Active role in shaping labor laws. Unions plays a crucial role in advocating and for influencing changes to the French labor laws. They act as a watchdog, constantly strive to improve the legal framework and ensures it adapts to the changing needs of the workforce. France's dedications to employees' rights isn't merely theoretical. It's a live reality woven into a fabric of its labor laws. This commitment manifests in a focus on the work-life harmony, unwavering protections, and collective empowerment, creating a secure and fulfilling work environment where everyone has the opportunity to thrive and contribute meaningfully. While the legal framework is intricate, understanding these key pillars empowers employees to navigate their work life confidently, knowing their rights are well protected and their voice can shape their futures. Collective bargaining and union rights. French labor in France, employee rights aren't sung by the lone voices but by a powerful chorus driven by collective bargaining and union rights. The potent forces power empowers workers to shape their destinies not just individually but together. Collective bargaining agreements imagine integrate Tips right is women by unions and the employees, detailing work conditions, compensations, and benefits tailored to specific industries or companies. DCBS goes beyond the minimum prescribed by law, offering enhanced protections and fostering a fair and equitable work environment. Union power. Unions in France aren't merely in standards by an active champion for workers. With nearly 95% of workforce covered by CBAs, unions amplify employees' concern, ensuring they resonate through the halls of power. Think of them as a megaphones projecting the collective voice of workers and ensuring their needs are heard loud and clear. Tailored solutions. French labor law recognizes that one side doesn't fill all. CBS can be negotiated at national industry and company levels, allowing a nuanced solutions which address the unique challenges faced by different sectors and workers. This flexibility ensures that rights and benefits are relevant and directly meets the needs of the specific group of employees. Beyond contracts, union involvement extends beyond mere bargaining. They play a crucial role in advocating for and influencing challenges to French labor laws. Imagine them as a watchdogs, tirelessly regarding employee rights and pursuing for the progressive reforms that continuously strengthening the legal framework. This collective approach fosters a dynamic landscape where employees aren't simply passive recipients of rights but active recipients in shaping their work environment. Collective bargaining and union rights empowers a unified voice, giving French workers the strength and influence, negotiating details, advocate for change, and build a more secure and fulfilling work life for all. Termination procedure and severance pay. In France, job termination isn't a sudden drop into the unknown. It's a carefully calibrated with process with clearly defined procedures and safety nets like severance pay. Let's explore this crucial aspect of France employee rights. Termination procedure. Justified reasons. Dismissals requires valid reasons, broadly categorizing person's incapacity or misconduct or economic company restructuring or redundancy. Employees must present documents, evidence, and follow specific steps, including preliminary meetings with the employee and a formal notification in writing. Notice period. Employees are entitled to a notice period before termination, depending on their seniority. This ensures time to find new employment and prepare for the transitions. For permanent contracts, this ranges from 1 month to 6 months or 2 years of the services or 3 months or executive positions. Employees' rights. Throughout the process, employees have the right to be transparent by the union representative or lawyer, challenge justifications for dismissal, and request a postponement. This severance pay eligibility. Permanent employees who have worked for at least 8 months are entitled to severance pay unless dismissal for the gross misconduct. Fixed term contract employees receive a similar payout based on their salary and duration of employment. Calculation. Severance pay is based on the average monthly salary over the past 3 or 12 months, whichever is higher. The formula varies depending on the seniority, starting with 1/4 of a month's salary per year of a service for the first 10 years and progressing on the third of each additional year. Minimum amount. French law sets a minimum severance pay threshold, ensuring an adequate safety net. Navigating termination procedures and understanding severance pay entitlement can be complex. Seeking advice from the union representatives or legal professional is always recommended to ensure your rights are protected and you receive the proper compensation. Social Security Bench, a safety net woman with benefits. In France, the concept of social security isn't just an abstract ideal. It is a tangible, comprehensive safety net woman with a multitude of benefits and that safeguards employees throughout their lives. Imagine A sturdy tapestry, each thread representing a different forms of protections seamlessly integrated to provide robust support. French social security rests on three main pillars. Number one is healthcare. Every resident, including employees, enjoys universal health care coverage through the National Health Insurance System. This ensures access to quality medical care regardless of income less level. Think of it as a study shields, protecting individuals from the financial burden of illness and injury. Second is the pension. French law mandates mandatory contributions to a national pension scheme. Employees receive a pension upon the retirement based on their lifetime earning, providing financial security in their later years. Imagine this is a comfortable hammock ensuring a dignified and worry-free transitions into retirement. Other benefits. The safety net extends beyond the health care and the pensions, encompassing unemployment benefits, family allowances, housing assistance, and disability benefits. These serves a helping hand during challenging times, offering financial support and enable individuals to weather life storms. Contributions and responsibility. Both employer and employees contribute to the social security system, ensuring the sustainability and universal coverage. This shared responsibility fosters a sense of solidarity and collective well being where everyone contributes to and benefits from the system. Complementing of the foundation. While Social Security forms the core of the safety net, many employer offers additional private benefits such as supplemental health insurance. This can cover expenses not fully reimbursed by the public system, providing even greater peace of mind regarding the health care costs. Life insurance. Employees may offer life insurance policy providing financial security for employees' family in case of death. Then the retirement saving plans. These plans can supplement the national pension, allowing employees to accumulate additional savings for a comfortable retirement. These additional benefits further amplifies the security and well-being provided by the French social security system. Understanding rights. Navigating the intricacies of the social security and benefits can be daunting. Seem daunting. However, several resources are available to assist employees. Union representatives. Unions can provide guidance and advocate for employees' rights within the social security system. Social security offices. These offices offer informations and assistance with assessing benefits. Online resources. Numerous websites and online guides provide detailed information about social security and benefits in France. By understanding their rights and utilizing available resources, French employees can fully harness the strength of the social security and navigate their work life with the confidence that comes from the knowing they were well protected and supported. French social security and benefits are complex with constant evolving. Consulting with the qualified professionals or union representative is always recommended for specific guidance and personalized information. By delivering deeper and understanding the system's workings, employees can weave their own thread of security and well-being into the fabrics of their work life. While previous overview painted a broad picture of employees' rights in France, diving deeper reveals of the dynamic legal ostriches, intricate, harmonious, and challenging counterpoints. Let's explore some specific aspects for more notions of understanding. Category specific right. Young worker. French law protect young workers under 19 through specific regulations regarding working hours, training requirements, and safety standards. Strict limitations on night work and hazardous activities ensure their well-being and development. Part-time workers. These employees enjoy the same fundamental rights as full-time workers, including minimum wages, overtime compensation, and social security benefits. However, challenges arise in terms of access to the certain benefits like unemployment insurance and career progression opportunity. Recent reforms aim to address these disparities and promote equal treatment for all workers. Precarious employment. The rise of non standard contracts like temporary work and the fixed term contracts raises concerns about the job security and limited access to benefit. While legal rights extend to these workers, challenges remain in negotiating better conditions and securing a stable employment. Enforcement mechanism and challenges. Labor inspectors. This body plays a crucial role in enforcing labor laws through inspections and investigations. However, limited resources and complex administrative procedures can hinder their effectiveness. Streamlining procedure and promoting technology aid inspections are potential solutions. Employee representatives, workers' committees, and trade union act as a watchdog, ensuring respect for rights and providing channels for the dialogue with employees. However, low unionization rates in some sectors limits their reach and effectiveness. Encouraging union membership and strengthening their role in workplace decision making could be instrumental. The next is the judicial system. French court provides a venue for the redressal in case of rights to violation. However, legal proceedings can be lengthy and expensive, discouraging individuals employees from pursuing legal actions. Collective actions through unions can offer better support and resources for navigating the legal system. The role of judiciary and the digital dilemma, landmark judgments we will go through. The French judiciary has played a pivotal role in upholding and expanding employees' rights. Cases like Ranier case on working time regulations and the Google Spain case on the right to be forgotten online demonstrate the continuous evolution of legal interpretations in response to contemporary challenges. Digitalization and the work rights. The rise of remote work and digital platform represents new challenges for safeguarding employees' rights. Issues like data privacy, workload measurement, and remote working conditions requires adaptations of existing laws and the development of new regulations to ensure adequate protections in the digital landscape. French employment in landscape attached triple women with the national code. Collective agreements and judicial pronouncements can appear perplexing to the seasoned professionals. However, bench with in a intricate surface lies a robust framework safeguarding year of rights as an employee. Let us embark as a guided journey, illuminating by the landmark case to defamate this intricate terrain and empower to the navigate it with the confidence. Ensuring equal opportunity and non-discrimination. Mrs. Dubious case, the Cour de Cassation 2017 case denied a protection due to the pregnancy. Mrs. Dubois found a recourse in the principle of non-discrimination enshrined in French law. Her victory secured her the promotions and set a precedent for the fair treatment and compensation for the lost wages and moral damages. Prioritizing young health, prioritizing your health and safety. A Monsieur Dupont case, Cour d'Appel de Paris 2020 case. Suffering chronic back pain, acute, unsafe working conditions, Monsieur Dupont found legal vindications. His case established employer negligence and secure compensation for medical expenses and lost income, highlighting the legal obligation to prioritize employee safety and well being. Achieving work life balance. Mrs. Chevalier's case. Burdened by the excessive overtime, Mrs. Chevalier sought redressal through the 35-hour work week stipulation of 2019. Code du Travail. Within the union support, she negotiated fair compensation and exceeding these limits, showcasing the legal framework's commitment to work life balance and fair remunerations. Empowered through transparency and communications. Mrs. Rose's case, Dear D Appeals D Line 2018, when Rosa's employer unilaterally altered his working hours. The 2018 Code Appeal D Lion affirmed his right to transparency. His contract was amended to reflect his agreed upon hours, underlying the importance of clear communication and mutual respect within the employer and employee relations. Protecting your privacy and establishing boundaries. Mrs. Duvall's case, bombarded with the work emails outside the designated hours, Mrs. Duvall found solace in the 2019 right to disconnect law. The court upheld her right to establish boundaries between the work and the personal life, empowering her to disconnect with and prioritizing well-being. Harnessing the collective voice. Mrs. Murray's case. Mrs. Murray's union successfully negotiated provisions in her collective agreement for overtime pay and improve her child care leave. This case exemplifies the valuable role of the collective bargaining in shaping fair working conditions and enhancing individual rights. Safeguard against the false accusations. The Bulgarian's case, facing unsustained accusations of harassment, Mrs. Bulgarian found protections in the 2021 Code panel safeguarding against false accusations. She cleared her name and sought damages for reputational harms and emphasizing the importance of due process and fair investigation. Investing in professional growth. MS Lopez case 2012 Court du Travail denied training opportunity offered to the men. Mrs. Lopez invoked the principle of professional equality. Her employer was ordered to provide training ensuring equal access to the learning and advancement opportunity. By concluding, we can say that a collective symphony for the future. Ensuring and expanding employees' rights in France is not solo performance. It demands a collective symphony where employees, union policymakers, and the judiciary play their instrument in harmony, addressing category specific challenges, strengthening enforcement mechanism, adapting to the digital era, and leveraging the role of judiciary are the crucial nodes in these ongoing compositions. By embracing collaboration and innovations, France can continue safeguarding its workers' well-being, allowing to melodify of the employees' rights to resonate through the economic and social fabric, setting the stage for a future symphony of the progress and prosperity. Thank you very much.